At the very beginning of any civil proceedings journey, there must be a civil wrong. This means that someone's act or omission has caused harm, damage, or loss to someone. Pay attention to the vocabulary. We say a civil wrong and not a civil offence. A civil wrong could be a breach of contract, an act of negligence, an infringement of copyright, a violation of human rights. The list goes on. After the commission of a civil wrong, the party who has been wronged, the claimant, may wish to initiate proceedings. Again, notice the vocabulary. I use claimant and not plaintiff because in England and Wales, this is the term we use nowadays. Before making a claim, however, parties should try to settle the dispute outside of court. Why? Well, for a number of reasons. Firstly, if every dispute which arose ended up in court, the courts would simply not be able to handle them. They would be totally overloaded. Secondly, who really likes going to court? Maybe you like going to court if you are a litigation lawyer, but for most individuals and companies, it's seen as a last resort. By last resort, I do not mean a place you go to relax for your holidays. A last resort means that it is considered as the final option at the bottom of a long list, only to be pursued after all other options have been exhausted. Why? Because, of course, going to court can be expensive, stressful, time-consuming, it can ruin people's reputations, and it can destroy companies. So the civil procedure rules, which govern civil procedure in England and Wales, have the main aim of helping courts to deal with cases justly and at proportionate cost. Under these rules, the courts are supposed to encourage parties to use alternative dispute resolution where appropriate. And annexed to the civil procedure rules are a number of pre-action protocols. These pre-action protocols contain steps which parties should follow prior to making a claim. Doing so can reduce the number of cases going to trial. So, what are these steps that parties should take which are contained in these pre-action protocols? Well, for certain types of disputes, such as those involving personal injury, professional negligence, and defamation, the parties should follow a set of specific steps which are set out in individual and specific pre-action protocols. However, even in the absence of a specific pre-action protocol, the court still expects parties to exchange sufficient information so that parties can understand each other's position, make decisions about how to proceed, try to settle the issues without proceedings, consider a form of alternative dispute resolution, support the efficient management of those proceedings, and so that they can reduce the costs of resolving the dispute. Now, compliance with this objective normally involves the claimant writing a letter before claim, also known as a letter before action, to the defendant. This letter should contain concise details of the claim, including the basis on which the claim is made, a summary of the facts, what the claimant wants from the defendant, for example, damages, and details about the sum of money claimed, if they are indeed claiming money. There's a good example of a letter before claim for a small claim to do with problems with goods on the UK's Citizens Advice website. Citizens Advice is a group of charities in the UK that gives free and confidential information and advice to assist people with certain problems, including legal problems. And the website contains lots of helpful information. So I'll put a link to that letter before claim in the show notes if you're curious and you want to check it out. So, once the defendant has received this letter before claim, he or she is expected to respond within a reasonable time. And this is normally 14 days in a straightforward case, but no more than 3 months, even in a very complex one. In this response, the defendant should state whether or not he or she accepts the claim, and if he or she accepts the claim, then, well, no further proceedings are needed. It's as simple as that. If, on the other hand, the defendant does not accept the claim, he or she must state reasons why, explaining the facts and parts of the claim which are disputed. He or she may also make a counterclaim. Now, a counterclaim is a claim brought by a defendant in response to the claimant's claim. I'll give you an example to make this more understandable. Let's imagine a car salesman sells a car to a buyer who pays by cheque. The cheque bounces and the buyer refuses to pay the £300 for the car. The buyer says that the car was in such poor condition, it broke down after a few days, and the buyer had to actually pay £1,000 to a garage to fix all of the terrible problems that were wrong with the car. The buyer makes a counterclaim. He says that instead of him having to pay the seller £300, the seller should in fact reimburse the buyer for the additional money he was forced to spend on the repairs. So there you can see there was an original claim by the car salesman who wanted the money, but then the buyer made a counterclaim, claiming that actually instead it wasn't him that owed the money, but it was in fact the car salesman who should pay. So compliance with the pre-action protocols is not compulsory, but parties who unreasonably refuse to comply may be effectively punished by the courts if the case does end up going to trial. To prove a point and to teach those non-cooperative parties a lesson, the court may in fact order the winner of the court case to pay the costs of the proceedings. That means all of the legal fees. So it might not feel quite so much like winning after all. Let me give you another example that we could relate to. Imagine you're a tenant in an apartment. You are renting an apartment. It's the middle of winter, your heating breaks. According to the law, the landlord, the owner of the property, the person who is leasing the property to you, is obligated to fix it. He should come and fix the boiler. However, he keeps saying he's too busy to come round to do it. He's got lots of Christmas shopping to do, for example. If you immediately take your landlord to court without trying to resolve the situation through alternative means, such as phoning up the estate agent, complaining to them, writing an email, trying to negotiate or mediate a solution, then the chances are that the court may well rule in your favour, but may not be as kind in their judgment as they would have been if you had indeed really tried to reach a settlement outside of court and complied with the pre-action protocols. Now, it's important to note that at any point throughout civil proceedings, parties can enter into what is known as without prejudice negotiations. These are negotiations aimed at reaching a settlement and where the parties can feel secure in the fact that all of the content of such negotiations is confidential and will not be revealed to the court if parties do indeed go to trial. And at any point throughout the civil proceedings, including even before proceedings have commenced, either the claimant or the defendant can make a written offer to settle the claim early without going to court. This is known in England and Wales as a Part 36 offer because it's governed by the Civil Procedure Rules, Part 36. Isn't that creative? The party who makes the offer is known as the offeror, and the recipient of the offer is known as the offeree. Acceptance of an offer stays the legal proceedings. This means that the claim does not proceed in court. There is no trial. If the offeree, on the other hand, rejects the offer, then this may be taken into account by the court with some negative implications in the judgment. So, whilst many cases do get settled outside of court, many do not, as you will well know if you are, in fact, a litigation lawyer. And in the next episode, we'll be looking at how proceedings are commenced. So that brings us to the end of this episode. Don't forget to send in your answers to my question, which was, what steps do parties need to take before bringing a claim in a civil court in your country? As well as that, don't forget to check out that link, which I'm going to post in the show notes for italki. And if you're a member of Study Legal English, you can of course find all your member benefits at studylegalenglish.com/episode 75. So thank you so much for listening, and see you next time.